another topic that we probably don't talk about enough, and Shem, I think it was earlier, kind of touched on all the documentation that he had done, and it wasn't effective. So only about 1 in every 10 family law cases statistically ever make it to a final trial. I think that's probably wildly overstated to begin with. So if you're in a case, we both have plenty of cases where we know, hey, eventually this one's going to end in a trial. It may be a year from now, it may be 2 years from now, but we're going to be in court on a trial. What can a dad do? What are the most effective things a dad can do to help his attorney? Because I always tell dads, I could work on your case 40 hours a week for the next 8 weeks, and you would still know 20 times the information about your case. So you're in a case, you've probably been involved in it for, let's say, a year, or maybe it's one of them, they come to you and say, hey, I got a trial setting conference next week, I need representation. What can a dad do right now to help prepare his attorney to be most effective at trial?
So I think that's a really great question because it goes to the attorney-client relationship, right? And you have to understand that, you know, you don't ask an accountant to do your taxes by sending them a shoebox of receipts. That's a highly ineffective way, right? You don't send 30 emails, right, with different little pieces of evidence, right? I think one thing you can do by to successfully work with your attorney to prepare for trial is dedicate one afternoon in the conference room, hopefully in person, right? Spread out all the pieces of the puzzle that you think are important and let your attorney take the top 3 pieces of evidence for each claim you have. You know, child support, whether it's defense or you're owed it. Custody, separate that. Legal custody, top 3 pieces of evidence. Because what you find after doing this so long is that, you know, a lot of things that the client thinks are relevant, like every little data point, every little possible piece of information, don't turn out to be relevant to the legal issues before the court. So just take one afternoon, okay, or a couple of hours with your attorney. Take all these pieces and just say, what are the top 3 key pieces of evidence that you think are relevant to prove up my right to have joint legal and physical custody or sole legal and physical custody, because that happens too, right? What are the game changers here, right? So what do I need to prove up my claim to establish my bond, to establish my rights here? And then looking at it from the perspective of trial, there's also just a very limited number of pieces of evidence that you're going to need to poke holes in the story of the other side. So we call it rebuttal evidence, but really what you're trying to do is attack the credibility of the other side. They're lying because Exhibit A, right? Took him to the doctor, took him to school, sign-in sheet, right? They're lying because here's the check I wrote, right? For Pampers, milk, right? Here's my police report when I went to the police station to pick up my kid and she didn't show up. There's very limited pieces of evidence that actually become relevant. So I would become laser focused if I were a client and try to understand the trial through the mind of an attorney talking to a judge. So that goes with acknowledging that not everything I think is important is true. We are constrained through time. Hearings, you get about 15 minutes. That's both sides combined. That's how much the court allocates to your case on a regularly noticed hearing. You can get into longer procedures. But at trial, you're still confined by a slot. And so usually you're talking about 3 to 4 hours for both sides to present their cases. Most people can't afford more than that because trial is so expensive. So I would, if I were the client, identify the 3 key pieces of evidence through the guidance of my attorney that help me prove up each and every claim to child support, legal custody, physical custody, and visitation. I would just laser focus on. That means you've got 12 pieces of evidence that you're really going to put forward on your case in chief. And I'd start there.
Yeah, I think that's a huge point for me, especially when you bring an attorney in the middle of a case. Maybe you change, maybe you've been self-represented, and you just drop 5,000 documents on my desk. Number one is it's going to take it would take me 15 hours to dig through them, and that's not even determining. That's not even figuring out what actually is useful.
Right.
So, I mean, Allison in the comments here, you need to do your own homework. You 100% do. I view if you hire me to represent you, we are a team, and I can't do it without you. And so you may give me a piece of evidence, and I'm sure Tamara, you have this too. Hey, this is the piece. This is what's going to win. And I look at the client, and I'm like, we're not even going to use it.
Right.
And they're so
Right.
confused because the best thing you can do is give your attorney the information. And then it's our job to drive the strategy.
Yeah.
That's where a good attorney-client relationship is.
Yeah.
Like,
So key points, Mark, how about use a Dropbox link and organize your own information into files? How about that? How about take those 1,000 emails and say one Dropbox links, right, with 5 files, each representing my claim: child support, legal custody, physical custody, visitation, right, property rights, whatever the issues are. And then here are my top 3 pieces of evidence that I want to work with you in identifying. And even if you have, like, 25, it makes it so much easier for the attorney to look at that information and go, oh, that's it. I'll pick this one. This is really helpful because we don't have infinite number. Nobody has infinite resources. Clients don't have, limits to their budget. Courts don't have unlimited times for your hearings and trials, and attorneys don't have unlimited resources to go on an excavation to find one document. So help them by just getting a little bit more sophisticated by using Gmail, a Dropbox link or a G Drive, and organize your information intelligently. So that involves you getting proactive in the education process. And then if you can't get the attorney on the phone, call the assistant. Say, hey, assistant, Mark's going to work on my visitation hearing. Can I send you a Dropbox links, or do you use Dropbox? Do you use Gmail, G Drive? What do you use? How can I best get this information to you? And that's another way, without using attorney time, where you can coordinate your efforts with the staff.
yeah. And I will say this too, on the trial piece, judges are human too. Um, we went to law school with judges. We were in classes with them.
Yeah.
They go to the same restaurants and walk the same streets. If an attorney walks in and says, I'm going to use 500 exhibits, the judge is going to be tuned out by the time you get through 10 of them.
Right, because you're blowing their calendar. The perspective of a judge is, I've got to move this case to disposition. On a domestic violence restraining order, I need to make a decision on this case. Okay. On a parentage case, I need a judgment on whether or not this person is the father, the parent. Okay. So you've got to get to the point where you realize a decision has to be made. It has to be fast. And you're so right, Mark, and so insightful to focus on the judge, because knowing your judge, doing research on who your judge is, going into court, these are things you can do for yourself right now. Go into court, observe all the COVID protocols, and sit through a whole day and just listen to what the judge is saying to the attorneys, is saying to the people unrepresented coming in through the courts. And I think that's a key piece of education for the client, because they're going to see that judges make decisions the same way we do. We're intuitive. Yes, there's a lot of law downloaded. We're very intuitive. We're observing your body language. We want to know that you're telling the truth. And really, we just want to know that if we give you custody and visitation with this child, they're going to be strapped in a seatbelt. You're not going to be drinking, get into a car crash. You're going to get them to school. It'd be great if you did some homework, right? But it's like, at the end of the day, we just want to make sure everybody's safe. Okay. And they want to make a decision that doesn't backfire on them. So get to the point, make it quick, study your judge, and laser focus in on the child.
Yeah. That's a big thing, especially, and I guess we can kind of turn to this, and we can talk about a little bit about mediation, because it's unique here in California. It's mandatory, and county by county is unique. But everything you do in court, whether it be mediation, whether it be at trial, whether it be in these 15-minute hearings, the judge needs to feel as if essentially the start of every sentence that's said by you or your representative is, I believe it's in the best interest of the child that.
There
Because
you
the
go.
minute, and judges are good at this, the minute they sense that it is personal, and I'm not, this is my comment, this is never a guest comment. Men are treated differently in family court than women are, in my opinion. My comment, no one else's. And But the minute they feel like it is about child support, it is about being vindictive, they're gonna note that. I know that a lot of people have beef with judges, and they're generally pretty good about catching that type of stuff. I'll get a lot of clients who the first thing they say is, "Hey, yeah, I want to get more custody to lower child support." All right, well, you called the wrong law office to do that. And most likely, you're going to go in there, and the judge is going to sniff that from a mile away, that it's
There
all about finances.
Absolutely. I think, what's so impressive is, when you have a judge who's been on the bench, who, has no problem making a decision, they so appreciate when you come in and you get straight to the point. And the judges that are in California, they're extremely savvy, meaning the fact they're seeing. So we get hundreds of cases a year, right? Judges are seeing potentially thousands of people every year. So it's rapid fire, right? So they're very attuned to the relationship between custody and support. Those are the two factors in child support, timeshare. So, I mean, the arguments cut both ways. Nothing's set in stone. You can seek a modification, but what you don't want to do is somehow misplace your lack of understanding about the court process. And you're talking about, once a judge and two lawyers are in court, you've got a combined experience of education, um, and talent and skill of about 300 years, right? And somehow, I think a lot of people, because they underestimate judges and even lawyers, that they walk away just blaming the judge. Well, that those are easy outs. Stop making excuses. Be proactive and ask, what can I do to change the narrative of the story that's being told on me in court? Because you can know absolutely nothing about the law, right? And say, I'm a good dad because, right? My child is so close to me, right? We're close. Here's the time we've spent. Here are the memories I have. Here's the pictures. Please don't rip me away from him. I've seen that be very effective in pro pers, even up against an attorney. Your Honor, I need my son. My son needs me. We're so close. I've done all I can to show you, if you give me custody back, the child's going to be safe. I'm committed. Here's my classes. I'm actively in therapy. I've taken my anger management courses, and I'm working on establishing civility with the other parent. Those things are so like intuitive and compelling that you're really going to gain an ally in court, when you speak to a judge from the framework of the best interests of the child.
Yeah, definitely, definitely.